Call to order. Celeste, please call the roll.
Debates, Evans. Here. Esserag.
Here.
Mead.
Here.
Rittenhouse. Lifka.
Here.
Stocking.
Here.
You have a quorum?
All right, thank you. Next item is the approval of this evening's agenda.
So moved.
Second.
Moved and seconded, all in favor?
Aye.
Opposed? Okay, next item is the approval of the minutes of the October 10th, 2019 meeting.
Move to approve.
Second.
Moved and seconded, all in favor?
Aye.
Aye.
Opposed? Okay, so we'll go on to our main topic today, the public hearing. We have one item on the agenda this evening. It's for the Fabyan Crossing Oberweis outlot. The applicant is requesting two items to be acted on this evening. First is the amendments to the Fabyan Crossing Plan Unit Development Ordinance 1993-45, 2017-10, and 2018-16, and the Resolution 2018-01 to modify the list of permitted uses, sign regulations, parking requirements, and previously approved landscape plan, all related to the proposed development of a sit-down drive-through restaurant on a new outlot number 1, and final plan unit development plan approval for a new outlot on lot 1. The location is 2100 South Randall Road, and the applicant is Oberweis Dairy. At this time, I'll read the procedure that will be following for the hearing, so everybody's on the same page as we get started. We're now entering the public hearing portion of our meeting. It is the Planning and Zoning Commission job to conduct these public hearings or receive testimony for and against petitions for general amendments to the zoning ordinance, zoning map amendments, zoning text amendment, special use permits, amendments to special use permits, and consider other requests for variations from the strict application of the City of Geneva zoning ordinance. The procedure we will follow is, for this meeting is as follows. First, the Planning and Zoning Commission Secretary or designated representative will read or describe written items, reports, and plans into the record. Second, the petitioner will present testimony in favor of petition and will present any supporting plans or exhibits. Third, the commission members will have an opportunity to question the petitioner. Fourth, the commission will then receive citizen testimony both for and against the petition. Questions about the proposal may be directed to the petitioner or the petitioner's witnesses, and questions about the Planning and Zoning Commission process itself may be directed to me. Following such testimony, the petitioner and the Zoning Commission may ask questions for those who testify. Finally, the petitioner may provide a rebuttal to any testimony in opposition. When all the testimony is brought into the record, the hearing will be closed, and the Planning and Zoning Commission will make a recommendation to City Council in the form of motion or motions. In order to give testimony, you must provide your name and address on the registration sheet located at the entrance of the hearing room and sign in the space provided. By signing the sheet, you agree that and understand anything you say will be considered sworn testimony and affirm to tell the truth, the whole truth, and nothing but the truth. When giving your testimony, please approach the lectern. Speak directly into the microphone so that you may be heard. Please begin by stating your name and giving your address. If you speak additional times, please state your name each time for the record. Please be concise when presenting your testimony, and if your point has already been made, it is not necessary to repeat it. Each of these points is recorded and will be considered as the Plan and Zone Commission develops findings of fact and recommendation or recommendations. You may provide your testimony in written form, but such written testimony must be presented to the Planning and Zoning Commission Secretary or designated representative prior to the close of the hearing. After the process is completed and everyone wishing to present testimony has spoken, the Commission will then decide whether it has heard adequate testimony in order to make a decision. If it has, the public hearing will be closed. After the public hearing is closed, the Plan and Zoning Commission will refrain from receiving any additional testimony either for or against petition. There is one exception to this rule. City staff will submit a report based on the testimony presented at the hearing. This report will consider comments and concerns from all city departments such as the fire department, Public Works Department or Engineering Department. Okay, any questions on the procedures? All right. At this time, I'll administer the oath for those who have signed the registration form. Anyone wishing to give sworn testimony, ask questions, or cross-examine anyone giving sworn testimony, please rise and raise your right hand. Do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. I might mention as part of the agenda that this is the first time we've actually hearing this item because it was originally advertised, but we didn't send out the notices correctly, so we had to reschedule it for this evening. So this is the first hearing this commission has heard for this item. David, anything on the record?
The contents of the application include a project narrative submitted by the applicant on March 19th, 2019, and a revised addendum and development schedule dated September 18th, 2019. A response to the special use standards prepared by Argianis and Associates dated September 17th, 2019. An access memorandum prepared by H.R. Green dated September 18th, 2019. Preliminary engineering plans prepared by H.R. Green, last revision date September 18th, 2019. A stormwater memo prepared by H.R. Green on April 26, 2019, last revision date September 18th, 2019. Existing facilities memorandum prepared by H.R. Green on September 18th, 2019. A landscape plan prepared by H.R. Green dated September 18th, 2019. A signage plan by Direct Sign Systems dated March 14th, 2019. Architectural elevations and screening prepared by DXU Architects, April 29th, 2019. A floor plan prepared by DXU Architects dated July 15th, 2019. A revised parking study prepared by H.R. Green dated April 16th, 2019. A traffic count data from the Illinois Department of Transportation submitted on September 18th, 2019. A photometric plan prepared by CREE dated March 20, 2019. A final plat of planning and development for Fabyan Crossing, Lot 1, prepared by H.R. Green, last revised August 7th, 2019. A staff report from the Community Development Department to the Planning and Zoning Commission summarizing the request and providing a staff analysis dated October 29th, 2019. A certificate of publication from the Daily Herald for the legal notice that was published on October 12th, 2019. A copy of the notification letter and a sworn affidavit saying that the notification letter was mailed to all property owners within 500 feet of the subject property.
Okay, thank you, David. All right, we'll hear from the applicant at this time.
Good evening. I'm Joe Oberweis. I'm the CEO of Oberweis Dairy. I'm going to keep my comments very brief because I think you've all heard them before, and then I'll let our technical team be able to answer any questions that you have that weren't addressed last time. The main piece that I want to add is why are we here again? And I think that very likely y'all might be aware, but just to make it clear, and the short version is the owners of the McDonald's property entered into a lease, and I think my understanding is that you'll hear from them and their perspective. And their lease, the best analogy I've come up with is it's like leasing a house and saying, I'm in the lease. We're not going to have a dog in the neighborhood. And then all of a sudden the neighbor buys a dog and they get upset with the neighbor for having a dog that they never had any jurisdiction on. So what I think is going to happen is that there's going to be all sorts of objections that are raised that have nothing to do with any of the standards for special uses, but are all ultimately about the provision of McDonald's lease that if another restaurant opens in development, they will have their rent cut in half. I believe it's completely irrelevant for the purposes of the city planning, but we're back here again because one of the conditions, which was in the report, was that we needed lot 5, I think. I don't remember exactly, but basically an adjacent owner to sign off in the easement. We're completely supportive ultimately of closing the electric loop with McDonald's, which, you know, if you're in the report. We have no problem with that at all. It's just we can't force an adjacent owner to do something. It's not in our capability. So we're happy to answer any questions that you might have. We have our appraiser, our engineer, and our architect as well. I think Todd, you're going to start. Is that right? Sure. So Todd is our engineer, excuse me, and then David is our architect, and Chuck is the appraiser.
Thank you.
Todd Richards with HR Green. Address is 420 North Front Street, McHenry, Illinois. The civil engineer for the project. I'll start off. So the subdivision is going to be, with the mouse here, it's going to be on Lot 1, and it's in the southeast corner of Lot 1, which is the location of the at-home store. So you can see that here's the new parcel, which will be the location for the Oberweis. It is all contained east of the access drive, and the access drive alignment is not being altered as part of this subdivision. The lot size is approximately 1.2 acres. So for the site itself, let me scroll to that. Bear with me. So the site plan itself, we've got the new Oberweis store, which is roughly 4,200 square feet, which is a dine-in restaurant and also has a drive-through. The dine-in parking is located on the east and south sides of the development, and there are 4 stalls that are west of the store that are for basically drive-through waiting stalls. The access to the site is at the southwest corner and is signaled, or is signed with a stop sign and another sign that says cross traffic does not stop to alert the traveling public. The drive-through pickup window is located on the west side of the building, approximately right where the hand's at. There's capacity for roughly 10 vehicles in the stack, and then any additional they would stack up along this east side of the development itself, still contained within the Oberweis parcel. The Oberweis parcel itself, we've got 66 total stalls, of which 4 are for the dine-in, or not the dine-in, sorry, the drive-through waiting stalls. And At Home has agreed to share 34 stalls, and those are located up here north of the Oberweis parcel. We went through, did a parking study analysis, and basically the total parking within the development itself, within the Oberweis, is 66 stalls. That actually meets the code requirement per the city. However, if you deduct the 4 stalls for the drive-through waiting area, then you would be at a possible deficit. Again, you have the additional shared stalls north of the Oberweis itself. So we also took a look to see what the demand is at a similar Oberweis store. So we looked at a Oberweis store with a 3-restaurant concept in it over in Bolingbrook. The peak usage that we have found was 26 stalls were occupied. So we believe that 66 stalls is more than sufficient for this development. We also took a look to see what the parking demand was for the at-home store itself. So we looked during a Saturday, peak times, and basically none of the parking east of the internal access drive was utilized. And there were still a number of stalls available west of the access drive. So with the Oberweis going in, we still believe that there is more than sufficient parking for the at-home store and also for the Oberweis store itself. For the utilities, go to the utility plan here. Bear with me. So the water and the sanitary sewer service will be connected over to the west, and they will connect to the existing facilities that are within the at-home parking lot. The water main will be an 8-inch, which connects to the existing 10-inch line, runs east up to the southwest corner of the building to a fire hydrant. From this fire hydrant, we are going to run a 6-inch line, single 6-inch line up to the building, and then that line will be split internally for the domestic and for the fire suppression system. The sanitary sewer service, it'll be a 6-inch line which connects to the existing 10-inch sanitary sewer main, and then that will be run up to the building itself to collect the grease waste or the kitchen waste and also the restrooms. For the stormwater, scroll back up here, bear with me. So in the existing condition, the majority of the site drains from west to east, and the stormwater discharges through a couple of depressed curb areas on that east side. It then discharges to this, to the drainage ditch, drainage swale. That swale then goes to the north, to the center access drive, to the overall subdivision, and then from there to the detention basin. There's a small portion of the site which is drained to a catch basin here. That line then runs north about 240 some odd feet, and then that line then turns east and discharges to that same drainage swale that's on the east side. In the proposed condition, the impervious area for the Oberweis is actually being reduced by roughly 4,700 square feet. That reduction in impervious area will basically not change the stormwater runoff and have any negative impacts. It will be either equal to or less than the runoff that is seen today that goes to the existing stormwater management facilities. For the building and signage, Oberweis is proposing to have 320 square feet of building signage with no sign being greater than 40 square feet. And this is in lieu of having a monument sign. Due to the unique concept with 3 restaurants, the additional signage allows Oberweis to convey that message of 3 different restaurants within the one building and to utilize their corner lot visibility to the traveling public. For the landscaping, let's see if I can find the landscape plan here. Bear with me. That is not it. There you go. So the proposed site is attractively landscaped with ornamental trees, shrubs, perennials, and ornamental grasses. We've worked with the city staff to come up with this plan that you see here, and it is in conformance with the 2017 amendment to the landscaping plan that was brought by Crown Group. And so this plan that you see is basically is compatible with that. And again, we conferred with city staff to come up with this plan. Let's see. And so with that, we've got, Oberweis would like to request that the city approve the amendment to the planned unit development. And with that, I'll open up to any questions, or if Chuck would like to speak at this time, or Dave? Yeah. You want?
Good evening. I'm Charles Argianis. I'm a commercial real estate appraiser. My office is in Downers Grove at 5509 Belmont, Downers Grove. My part of the work that I did for Mr. Oberweis was contained in the report that I wrote. It's dated September 17th, and I went through the 9-step presentation that a real estate appraiser is supposed to consider for whether there would be a value diminution in a property by virtue of the proposed concept. There are 9 elements. I'm not going to read it verbatim, but the 9 components are: number 1, the proposed use of the specified location is consistent with the comprehensive plan. Number 2, the proposed building or use will not diminish the value of adjacent or nearby properties. Number 3, the proposed use at the specified location will not substantially or unduly increase traffic congestion, and on-street parking demand in the immediate vicinity of the proposed use and in the area affected by traffic generated by the proposed use. Number 4, and by the way, the rationale for all of these findings it's all presented in my report. I'm just reading the bullet points. Number 4, the proposed use has been designed to provide for adequate ingress and egress to minimize potential vehicle conflicts and congestion in public streets. Number 5, the proposed building or use will not adversely affect or change the character of the area in which it is to be located. Number 6, the proposed use at the specified location will not adversely affect the use and development of adjacent and nearby properties in accordance with the regulations of the district in which they are located. Number 7, adequate utility, drainage, parking, and other necessary facilities to service the proposed use will be provided, and such utility, drainage, parking, and other necessary facilities will not adversely affect the use, development, and value of adjacent and nearby properties. Number 8, the proposed building, other structures in use comply with any and all regulations, conditions, and requirements of the city applicable to the building, structure, or use. And finally, number 9, the exterior architectural appeal and function of any proposed structure will not be at variance with either the exterior architectural appeal and functional plan of structures already constructed or in the course of construction in the immediate neighborhood or the character of the applicable district to cause a substantial depreciation in property values in the neighborhood. I'm sorry for the long presentation. The meat and potatoes of my work, however, are presented on page 3 of the report that I wrote. And on page 3 of that report, what we did is we researched, and it looks like this, by the way. And this is merely a chart, and it's an indication of where the Oberweis facilities have been constructed. And there are 3 locations. One is in Bolingbrook, one survey area is in Bloomington, McLean County, and the third one is in Champaign. And what we did is we researched to see, after the Oberweis facility had been built, whether it resulted in a diminution of other restaurant properties or commercial properties in the area. And the fact of the matter is, we learned that not only did it not result in a diminution, but rather it caused an increase in values. I'm sure that there's a whole bunch of other reasons why values increased in these areas at all, but I'm happy to report there's absolutely no evidence of diminution by virtue of the Oberweis facilities being sited next to Buffalo Wings, Panera, McDonald's, Chick-fil-A, Chili's, Smoothie, Culver's, just Steak and Shake. There's no evidence that opening an Oberweis facility is the one that's contemplated resulted in a value diminution in any of the properties within its immediate vicinity. That's it.
Okay, all right. Thank you.
Thank you.
Do you have anything else? Is that your presentation?
No, thank you. The reality is this is, I think, a very straightforward, simple development that, in the absence of the lease with McDonald's, this would all be very simple and straightforward. I mean, it's very standard use in the area, very standard traffic flow. We're not, this is not a major departure from what's happening in the vicinity. So, happy to answer any questions if you have them, or we can, I don't know, do you say questions for the end, or?
Well, there's time for questions now. What's the material change that's been done to the plan versus what we saw the first time?
I don't think there's any.
The electrical,
Oh, that's, yeah.
so the electrical line no longer is being shown extending to the east and up along Lot 5.
That's it?
That's it?
That is it.
That was the question I was going to ask. Exactly what are we seeing that's different?
That's it, yeah.
So,
So, because power was always coming from, was it the west?
The
From-
west.
Yeah, and that was just a redundancy that was built in.
which in a perfect world, the city would like to see, and that would have been borne at your cost, right? All that redundant line?
I don't think so. I don't know.
It would have been
Would
it would have been the cost of your development to
Yeah,
run that
to
redundant line.
Put it in.
Right, it's a
So
good-
arguably, the owner of the McDonald's site would also benefit from that
They would.
redundancy, because as I read it, I don't think they have redundant power at this point either.
That's correct.
That's right.
So they would have benefited at no cost, which would have been something that would arguably be attractive to that landowner as well, right? Okay.
Okay, any other questions today? Okay. Thank you. All right, so we'll hear from anyone else that wishes to speak on this matter.
My name's Chris Ward, and I'm here speaking on behalf of Dial Realty, Geneva LLC, and Geneva 2 Incorporated, address 11506 Nicholas Street, Omaha, Nebraska. I'd like to object to the approval there for we've got three points that we'd just like to bring to the attention of council. We feel the ECR was improperly amended, and such an amendment has a materially financial impact on other parties in the shopping center, and that the agreement going back to 1995 should not be amended to harm any parties for the benefit of any parties. We are currently in litigation regarding this matter. Second point, we have the letter from Argianis and Associates, I believe probably that was referred to, dated September 17th, 2019, which was submitted to the city. We'd just like to note that Argianis states that the McDonald's ground lease will not cause a diminish in value. That is notwithstanding the letter acknowledges that McDonald's rent shall be reduced by 50%. It defies logic that the reduction of 50% of rent would not decrease the value of adjoining lots. And then lastly, they have submitted a drainage plan, which we've not had an opportunity to review. Such drainage could materially impact any future drainage on our lot, if ever developed, or possibly prohibit future development on our lot. Thank you.
Thank you. Any questions?
I just got confused who you represent.
One of the lot owners. So Dial Realty, the original Dial Realty Geneva originally developed in 1995 in the ECR, and are still a lot owner.
I have a question
Yes.
also. Could you elaborate on how this might prevent development of another lot?
I think that has to do with the drainage that they have not actually been able to review, and it sounds like that may have changed somewhat. But the other piece is the diminishment of value that would affect development on that lot. Future tenants.
Okay, thank you.
Any other questions? All right, thank you.
Thank you for your time.
Anyone else wishing to speak on this matter?
One second, if I may, sir.
Oh, sure.
Yeah, he's
Is it Ms. Ward? The woman that spoke, because she was referring to agreement, that's an agreement between the parties, not between. I think that ought to be clarified for the record.
Before you start, sir.
Yes, sir.
Yeah, Ms. Ward, is Ms. Ward?
Yes.
Yeah, if I could, my name's Charles Radovich, I'm city attorney for Geneva. So I just want to, for the record, a clarification here. You referred to CCRs, which covenant conditions and restrictions of record, correct? 1995. That agreement was between whom?
That agreement was between the developer, which would have been the Dial, and the tenants at that time.
At that time, okay. The city of Geneva was not a party to that agreement, is that correct?
Not to my knowledge.
Okay. Thank you.
I'm sorry, thank you.
Please,
All
sorry.
right.
Phil Lutkehans, Lutkehans. I represent Bear Valley Partners, which is the owner of Lot 4, which is the McDonald's. A couple clarifications. Just so we're clear, Dial owns Lot 5, which is the drainage, which is the detention pond. It was not McDonald's that was asked for, or my client that was asked for the easement along our property. And it was denied. It was actually Dial for Lot 5. I just want to make that clear, because it sounded like someone thought maybe it was us that was denying it, and that is not the case.
Thank you.
Just for clarification. I think maybe the best way to start is I have questions for Mr. Argianis, and would like to start there if at all possible.
Okay.
That's okay, if you can't hear me. I think you said that those 9 factors were required to look at whether value was being diminished. Is that what you testified to in your opening?
What I mean is that those 9 factors are typically the 9 elements that a real estate appraiser uses in making determination as to whether there's a value diminution by virtue of a proposed or contemplated development.
And where would I find that in the appraisal standards?
It's not in the appraiser standards, but I've testified many times throughout the state of Illinois, and those are the 9 elements that are always at issue.
Those are the 9 elements always at issue in a zoning case, correct? You wouldn't, if you were in a condemnation case, those would not be the elements, correct?
They might or they might not. I don't know. We're not in a condemnation case, so I didn't contemplate that.
But these are the 9 factors that are in the Geneva ordinance, is really what you were quoting word for word, correct?
Well, I don't know if I quoted them word for word, but those are the 9 factors that I considered.
Okay. And for the record, you're not a land planner?
No, I'm not.
Okay, you're an appraiser and a lawyer, correct?
That's correct.
Okay. I see from your report and your CV that you've done a significant amount of appraisal work as it relates to fast food restaurants and Geneva area appraisals, is that correct?
Yes, it is.
In fact, you've been doing this type of work since the 1980s, is that fair to say?
It is.
Looks like you became a lawyer in about 1986,
Give or take, yes.
and before that you were actually a practicing appraiser, correct?
Yes.
Since those early 1980s, do you have any idea approximately how many retail establishments or shopping centers you've appraised for one reason or another?
Probably hundreds, maybe even thousands.
And how many of those would you estimate were ground leases? Fair amount?
Many of them.
Okay. So I guess it would be fair to say you have a great wealth of experience in the area of appraising both retail properties and underlying ground leases on those properties, is that correct?
It is.
When you do an appraisal, is your normal practice to talk to people involved in the underlying sales and transactions?
It is.
Did you look at any underlying sales and transactions when preparing this work?
Yes.
What sales did you look at?
I have a subscription to a database called CoStar, and I pulled sales of product within the area, and I looked at it, but to the extent of looking at it, I didn't have a specific mission. I just looked at it. I think if you follow real estate trends over the last 10 or 15 years, pretty common knowledge that the real estate markets crashed by virtue of oversupply. But I think it's also pretty common knowledge that markets have since recovered and things are looking pretty good right now.
Okay. And did you list any of those sales you looked at in your page 3 of your report, which is the meat and potatoes of your report?
No.
And normally when doing an appraisal, you look for comparable sales to determine value, correct?
Well, that's one of the things I do. In the specific interest here, I looked at assessed values as well. And universally across the board for the properties that I surveyed, the assessed values went up. And to the extent that the assessor is a credible source, I'm willing to buy off on the fact that if the assessor thinks that values are going up, I don't disagree with that. And
You've testified in court numerous occasions, correct?
yes,
Have you ever testified in court solely on appraised assessor's values like you did today?
yes, many times.
Solely on assessor's values, and you were allowed to testify in court?
Well, it's not at all unusual for me to testify as to the the market value of a property, which is the underlying foundation for an assessed value for a property.
Have you ever testified in court relying solely on assessed valuations?
No.
Did you interview anyone other than the Oberweis people regarding the Oberweis effect on neighboring properties?
No, I did not.
Did you interview any developers as to how an Oberweis development could affect the neighboring parcels?
No.
And you did not interview any developers regarding whether the 50% reduction in lease rent on a ground lease would affect values, did you?
No, I did not.
Okay, in your report, the only data you provide this board is assessed valuations to show there was no diminution of value in neighboring properties, correct?
No. If you read the report I wrote, there are the 9 elements, and each element has a narrative that explains why I concluded what I did.
Any data other than what's on page 3 of your report?
No, not in the report.
And page 3 of your report is strictly the assessed values of the property, correct? Of properties.
It's values of properties within the immediate proximity of the Oberweis.
Did you talk to any of those assessors?
No,
Did you check whether any of the neighboring properties in the 3 projects you looked at included a lease provision where the rent would be reduced by 50% if this type of development was built in the same shopping center?
no, because it's irrelevant.
Question is, so the answer is no, you did not.
No, I did not.
In fact, 2 of the 3 properties you looked at are near McDonald's that you mentioned are not even in the same shopping center, are they?
No,
Is that correct?
correct.
Okay. And, let's talk about those other locations for a second. The one that is in the same shopping center is the Bloomington, correct?
Correct.
The one in Bloomington, how far away, Bloomington, that only contains an Oberweis dairy and a burger joint, correct?
I'd have to look at my report. I can't remember off the top of my head.
Oh, feel free, it's not a memory test, Mr. Evans.
This is when Oberweis opens up.
So the question again is,
The Oberweis, or the property in Bloomington that you're looking at, only contains an Oberweis and a that burger. It doesn't contain a pizza place, correct?
in Bloomington? I have that it contains a Blaze Pizza on College Avenue.
What it doesn't is part of it doesn't have, the Oberweis development there, the Oberweis store only contains the burger joint and the Oberweis.
Correct, that's
I
correct.
probably didn't ask that correctly, so I apologize.
All right.
But McDonald's is about a half mile away around the corner, correct?
It is, yes.
Okay, so it's not across the street, it's not next door, it's a half mile away.
About a half a mile, yeah.
Okay, so let's talk about Champaign. Again, the Champaign property only contains an Oberweis and a burger joint as well, correct?
That's correct.
And McDonald's is, well, it's on the same street, it's about 4/10 of a mile away, correct?
I don't know about 4/10, but it's close. It's about right, probably.
I mean, it's about 4/10.
I don't know about, yeah, I'd stipulate to that.
Okay, it's not, again, it's not in the same development.
No.
It's not in the same shopping center, it's not right across the street.
No, it's not.
Okay. Did you find any other Oberweis dairies next to McDonald's? Oberweis burger joint places next to McDonald's in the area? In Chicago, Illinois, City, Illinois.
They're probably out there, but these are the ones that I surveyed.
Are you familiar with the Skokie?
I know there's one there, but I don't have details on it.
The Skokie also contains an Oberweis and a burger joint, correct?
If it does, it does. It's
Well,
not
do
in
you
my
disagree
report.
with me?
I don't have that detail.
Okay.
I didn't look at the property, I don't know.
Would it surprise you if I told you that the McDonald's assessed value has gone down over the past 4 years? The McDonald's right next to the Skokie Oberweis, the assessed value has actually gone down over the last 4 years, not up.
No, it wouldn't surprise me at all.
There's a lot of factors that go into it.
But you didn't include that sale in that actual property in your analysis, did you?
There was 1 million sales. I picked 3.
You picked 3, one in Champaign, which is, what, 3 hours away from here?
Well, because I was aware of it.
Well, you had Oberweis, they could tell you where all their stores were, correct?
Oberweis didn't tell me what to do and what not to do.
Okay.
I had a short period of time to prepare my analysis, and I picked Representative Oberweis's, and I ran with them.
And you forgot the one that was the second closest Oberweis burger joint. You didn't check that one out, the one that was second closest to this property.
I didn't forget anything, sir.
You didn't look for it, you didn't find it.
I looked.
Did you find it?
Whatever I looked at, I picked data, and I put it in the report that I could verify. I didn't want to put data in the report that couldn't be verified or which might be counted as being hearsay.
Are you telling me that the Skokie data, you couldn't verify it? You couldn't do the exact same thing you did for Bloomington, Champaign, and Bolingbrook.
Look, I was not aware of Skokie, but having said that, Skokie, the fact of the matter is, if you look at a Crane's business issue about 3 or 4 weeks ago, it stated that property values in Skokie have gone up about 70 or 80%. So to the extent you have one property that went down, how do we know it didn't have a fire? Or maybe they needed a new roof, or maybe it had some deferred maintenance or capital expenses. I mean, there's so many things that could go wrong. But the fact of the matter is, property values are going up, sir. They're not going down. And to put me on the stand here and tell me, you know, I was unaware of a property in Skokie, what if I came in here with 1 million Oberweises and did every one of them? You got 3 data. 3 data is sufficient for what I think is supportive of my report.
I understand you think it's sufficient.
I
I'm
do.
just asking the question, Mr. Adjournment, and that is, you picked Bloomington, which is over 100 miles away, correct?
Correct.
You picked Champaign, which is even further away from here, correct?
Correct.
And you did not use the Skokie site, it's closer than both of those, correct?
That's correct.
Okay, thanks. You work with, in all these hundreds, thousands of appraisals, you work with retail developers, correct? That's some of your clients?
All the time.
Okay. And you do appraisals for developers before they purchase the property, correct?
Sometimes, yes.
And you also do appraisals for banks or lenders prior to the purchase of retail properties, correct?
Correct.
In those appraisals, have you ever seen a developer or lender accept an appraised value based solely on assessed valuations?
No.
What information or due diligence do developers that you work with utilize prior to determining whether to buy a property with a ground lease on it and at what price? Do you know?
The same evidence that assessors use. People look at data, they look at sales, and they render an opinion of value based upon market data. I'm fully familiar with the Batavia area. I'm fully familiar with the subject property. For all I know, when I was younger, I may have appraised that property for proposed construction. I've been around a long time, and there's no way that a proposed Oberweis is going to have a diminution or negative impact on the value of that shopping center. It just isn't so.
We're aware of your opinion, Mr. Adjournment.
All right.
You absolutely have the right to. I'm just trying, I think I have the right to ask the questions that bear on that opinion, and that's what we're going through.
Okay.
Okay. Normally, developer would want to know the lease rights, correct? If he was going to buy a property that had a lease on it for a ground lease?
Correct.
The length of the lease,
Yes.
quality of lease,
Yes.
and those are all items that affect value, correct?
Yes.
In fact, for commercial development, whether it's industrial or retail, the first thing most sophisticated developers look at is the income approach, correct?
It depends. Not every development is an income-producing real estate asset, so
But if you have a property that is an income-producing real estate asset, the way it is valued is based on the income approach most of the time. Would you agree?
much of the time, but I wouldn't say most of the time because there's always nuances to every property is different and properties are developed for different reasons.
And when you provide an appraisal, let's say for court, you usually will give us give a couple different approaches to value so that you can make sure that you get as much data as possible, correct?
It depends on the time and, you know, the ability, the scope of the work. I mean,
I'm sorry, I didn't mean to interrupt you.
all right, go ahead.
Often you use comparable sales, correct?
Yes.
Often you use income approach,
Yes.
and often you might use, I forget, reconstruction, that's not the right word.
Construction, cost approach.
Cost approach, I apologize.
All right.
Doing this off memory, which isn't very good.
Well, it's going good.
In determining the income approach, one of the things you look is the capitalization of the cap rate, right?
That's true.
And what, given this market, and I know it's not going to be exact, so I'm not trying to hold you to an exact number, I'm just trying to get a handle on it. What would a cap rate be for this type of market for a retail user?
What kind of retail? There's a whole different
Let's
range.
just use the McDonald's,
You get McDonald's credit.
or the Oberweis, I don't care which one.
Certainly, I mean, those are national credit, those are credit entities, and a cap rate would probably be around 5.5% to 6.5%. Maybe lower, because right now the cost of purchase capital is very low, it's affordable. So right now, people are buying up properties at premiums that a couple of years ago people would have thought would be unheard of.
Okay, so let's just kind of walk through how how that approach works, the income approach with capitalization, okay? Just so everybody's clear.
Okay,
And we can take 5% because it's a nice, easy number. And it may be slightly low, but it's in the same ballpark.
you know what? Got my
That's what we got
calculator.
it for, thank you. Because I had one in the back and I was hoping I wouldn't have to bring it up.
I got it.
Okay, so let's say, in this case, the lease rate is $5,000,
Okay,
and we're using your 5% cap.
okay.
What would they, based on just that cap rate, I know there's other nuances, don't get me wrong, but based on just that cap rate, what would the value be?
Well, a cap rate is, you have an equation, and the numerator is the net operating income, which in council's example is $5,000. And the denominator of the expression is the cap rate, which would be 0.05. So we would take $5,000 as the top of the equation and divide it by 0.05, and it gives an answer of $100,000.
Okay, now if I was to do that same cap rate analysis with a $2,500 rent instead of $5,000, I would end up with $50,000, correct?
Yeah, you get a lower number.
Half, in fact, half.
Yes.
Just simple math.
Yeah, it's just mathematics.
Yeah, no problem. Okay. Would you say that your opinion here would be an appraisal under use cap?
It's not really intended as an appraisal. I didn't do an appraisal of any property here. What I did is I came here to present a presentation about whether there would be a diminution in value. You don't have to do an appraisal in order to give testimony as to whether there would be a diminution in value.
Let's talk about use cap for a second. Those are the guidelines put out by the Appraisal Institute.
Right, they're the rules of the road.
And you're a member of the Appraisal Institute.
I am.
In fact, you have an MAI designation, which means master, I think, does it?
Member. I'm a member of the Appraisal Institute.
Didn't mean to.
It's okay.
Do my best.
It's all good.
And you're also familiar with the Appraisal Institute guide, is that correct?
The guide?
Guide notes for the standards of professional practice of the Appraisal Institute?
Yeah, but the guide notes are not to be considered rulings. They're persuasive, but they're not intended to be exact, and they're not necessarily indicative.
Okay, would you agree with me that the guidelines state that guidelines further clarify that broker price opinions, automated valuation models, and tax assessment values do not suffice in themselves as evaluations?
Yeah, if that's what it says, I would agree with it.
And they're kind of the group that sets the standards for appraisals in the United States of America, correct?
Actually, they're not. It's the Appraisal Foundation, which is, they report to Congress, and then Congress passes laws.
Okay, but you're a member of the Appraisal Institute and you follow their guidelines?
Yeah, I do follow. I try to follow them universally.
Okay. Just to be clear, you did not do a full-blown study appraisal on the effect of this project on property values before and after the development?
I didn't do a full-blown, I didn't do any appraisal. I didn't do an appraisal. It's not what I did.
But in the past, you've done full appraisals using compared sales study analysis or a before and after analysis to determine this?
Yes.
And you didn't do that, you're honest?
No.
You admit that, I'm not
Yeah.
trying to make it.
Not admitting, I just didn't do
How
it.
long would that take to perform that kind of analysis?
Probably about 18 days. The appraisal itself takes a couple days, but to get all the information and formulate it and put everything together probably takes a week or two, because you don't just take data and write a report. You got to verify the data is correct, and that's the hard part.
You make calls on the sales, make sure the sales are correct, check green sheets, correct?
Yeah,
And you sometimes call people that are part of the sales to double check them, right?
you do, yeah.
And just so, and I kind of skipped this step, but just so everybody understands, before and after, or a paired analysis would say, okay, here's a sale before, and here's a sale after, and here's how, if there was any effect by the intervening property or, correct?
Correct.
And you've prepared sales with a controlled target group analysis, or appraisers with that, sorry.
I don't know what a controlled target group is.
Okay, fair enough. Let's go through your September 17th, 2019 report. And I apologize, I think I left it in the back.
Mr. Chairman,
Yes,
can I ask you a question?
certainly.
Is this the right forum for this kind of question and answer of the participants? I feel like this is more being treated like a court of law. He even said he was on the stand at one point, which is certainly not the case. And I'm not even sure we're being addressed as a commission. I feel like he's more addressing the representative for the petitioner.
I would defer to our city attorney on that opinion.
Well, I think the process allows for an objector or counsel for an objector to cross-examine a witness. So you have testimony from the appraiser for the petitioner here, and so I think there's some latitude that the commission ought to give, even though he's not addressing you, he is addressing the appraiser's testimony and report. So I'm sure that he'll be as prompt as possible in his questioning, because he doesn't want to belabor his questioning either.
Correct.
Correct.
About 3/4 through, so.
Okay.
Mr. Radovich well knows I have the right to cross-examine and declare a decision. So that's that's really all. So if we can go through your report, you have it handy?
I
Mr.
do.
Arginos? Okay.
Yes.
Just so I'm clear, I think I said earlier, you agreed earlier, you're not a land planner, correct?
I'm not a land planner, no.
And you don't have any certifications or licenses for land planning duty?
No.
And the testimony and expert witness experience you have that's listed in your report or in your CV at the end, that's all related strictly to appraisals, correct, or land valuation?
Well, property valuation.
I'm sorry. No land planning, you haven't testified as an expert.
No, I'm not a land planner.
Okay. Near section, section 2, you're really, in my, I think it's twice in your report you talk about the issue, when you look through the 9 factors for that ordinance. Twice in your report you talk about the diminution of that, correct? I think it's, when you talk about notes, paragraph 2, and I think maybe later paragraph 7, we'll talk about it. So paragraph 2, you definitely talk about that, correct?
Correct.
And you rely, for your opinion, of no change in value. The data you have to rely upon, as we discussed earlier, is the data that is on page 3.
Well, it's part of the data.
Well, it's the data you've provided this commission.
Well, but there's other data that's been read into the record that I consider too. The plans, the survey, the ground lease for the McDonald's. I mean, there was a lot of details.
Any sales data that we have that you've presented to this commission other than the ones on page 3?
No.
You also state in the bottom of page 4, at the end of paragraph, your notes on paragraph 2, one of the things you rely upon and the basis for your opinion is that the Oberweis will bring additional tax revenues to the community. Do you see that?
Yes, I said that.
Okay. Are you aware that that is not an actual admissible standard in zoning cases? That that's not an issue that this board can consider?
Well, I stated it because I believe it.
Okay. But you're also, are you aware of the fact that the case law in Illinois is such that that is not a relevant factor in the South End?
No, I'm not.
Okay. said the building, proposed building will not adversely affect or change the character of the area in which it is located. And one of the bases for that opinion, again, is that the development will not cause a diminution in fading across the neighbors or surrounding properties. Do you see that?
Yes, I said that, and I believe it.
And so at least one of the bases of your opinion that factor number 5 is met is for the lack of diminution of value, correct?
Correct.
Other than in Cook County, how often do other counties reassess? Every 4 years, correct?
Well, some counties can assess whenever they want. The old days, it was quadrennial, then they changed it to triennial, but some jurisdictions assess every year.
Are you familiar with Champaign County reassesses every year?
Not off the top of my head,
Are
no.
you familiar whether McLean County reassesses every year?
Not off the top of my head,
Are
no.
you familiar whether Will County, which is the Bolingbrook property, reassesses every year?
Not off the top of my head, no.
One second, if I may. We have nothing further, Mr. Argianis, at this time. Thank you.
Can I ask Mr. Oberweis a question?
Oh, certainly, yes.
Mr. Oberweis gave me the permission to state the reason there's no diminution in value to the McDonald's is because the clause that calls for a lowering of the rent is already written into the lease. So the risk of a value diminution was already there when the lease was written. So there's really no value diminution because the lease already has this clause. It's just that something is triggering it. But if I were the buyer of that property, and if somebody said, what's the risk of this property? I would say, well, it's going good right now, but there's a risk that if something happens, that rent can be diminished. But the value of by virtue of the Oberweis being built, that's not causing the diminution. The diminution is the instrument itself. The lease already has that clause written in it, and they wrote that into the lease when that McDonald's lease was signed. So the risk is already there.
As I said already, I have nothing further, Mr. Argianis.
All right,
Okay.
thanks, thank you. Do you have anything further?
Oh, yes, sir.
Thank you.
At this time, I would just ask to enter a number of exhibits, Bear Valley Exhibits 1 through 7. I'll talk about each of them at some point here in a second, but how best you want me to do that is up to the,
You have to hand it to me. Do you have extra copies that the commission can see?
almost everything.
Okay,
I tried to.
I won't hold you to that, but it'd be nice if everybody had a copy of it.
I don't know, I think I have like 9 of those, so hopefully I have enough for everybody who didn't know.
Do you have a copy for the petitioner?
If I can have one of those, I can have this.
Can I have that one? Oh, sorry. I thought he wanted to pass.
Exhibit 1, which was just placed in evidence, which we talked about a little bit, is the McDonald's lease. We'll talk through that a little bit later with one of our witnesses. Exhibits 2 and 3. Bear Valley Exhibit 2, which I'll hand the petitioner into the commission here in a second, is April 26, 2019 letter from Tim Elliott to Jody Henninger. And Exhibit 3 is August 28, 2019, correspondence from Mr. Elliott to myself. Mr. Elliott, for the record, is the attorney for McDonald's. These are just the letters from McDonald's attorney stating that they will decrease the rent by 50% and all their payments upon the operation of an Oberweis with a, quote, drive-through. We also have, and I don't have them all marked, exhibit number, but we do have exhibit 5, which is a case called Bossman, B-O-S-S-M-A-N, this versus the Village of Riverton. For the record, I will just read in part of exhibit 5, which is a appellate court opinion from 1979, the 2nd District, which is where we sit, that says, justification for rezoning of this property in anticipation of an increase of the tax base of the community is totally illusory and totally violative of all the basic principles of zoning. I raise that before you because that is what Mr. Argianis relies upon in paragraph 5 to meet factor 5. And that is an improper use of, it's not an actual standard that can be relied upon and should not have been relied upon by Mr. Argianis. Exhibit 6 is Concerned Citizens from McHenry versus City of McHenry. Again, another 2nd District opinion, just confirming what is in Exhibit 5. That says, and quote, the argument that rezoning would increase the tax base as opposed to conserving the tax base has been rejected. Such a justification is totally illusory and totally violative of the basic principles of zoning. So to rely on that, the additional tax base as a factor or as a reason for rezoning is improper and there is no support for that factor here. We also have for you, I'll present to you Bear Valley Exhibit 7. I'll wait till you pass that out before I talk about it. Okay? This is an Oberweis / burger joint store in Skokie. The document you have in front of you are the real estate taxes for the McDonald's across the street. As we saw earlier, as I think we all know, Skokie is a lot closer than Champaign and a lot closer than Bloomington. In this, what you will find, if you look at the left side and the back page, the tax billed amounts and tax history on the left side, you will note that the tax value has gone down since 2015. You will also see the actual assessed value history on the second page, also showing the assessed value going down. Assessed valuations are not value. They never have been in Illinois. They're not the type of value that you can rely on and should rely upon. There's some, as the Appraisal Institute says, they can be used along with other comparable sales. They shouldn't be used as the total basis to show an increase or decrease in value.
Hang on a second.
Excuse me.
Yeah.
Did you supply exhibit number 4?
I skipped 4.
Okay, just making sure.
No, that was me because I don't know if I'm going to use it, so I apologize, and everything was pre-numbered. Yes, so I got 1, 2,
Just making
3,
sure.
5, 6, and 7 that we would ask be admitted into evidence. And thank you for, I should have said that myself, I should have noted that. But as Mr. Argianis said, we don't know what happens to these properties and why stuff's been assessed or why assessments have increased or decreased. That's why they're not allowed to be used. That's not what appraisals do. And we will have an appraiser here in a minute and testify what you should be looking at and it's not assessed valuation. This time we would ask John Monday to testify.
Sir, would you please identify yourself and who
Sure.
you're affiliated with?
John Mundy, I'm an appraiser and consultant. The address is 1301 West 22nd Street, Oak Brook. Been appraising for about 45 years. M-U-N-D-I-E.
Thank you.
If it's acceptable, do you mind if I just turn this mic on so maybe it'll be easier to hear?
Yeah,
I don't mean anybody to think
sure.
I'm part of the
Anything that-
committee, but I think it might be
Yelling.
easier for
Yeah, that's
everybody.
fine.
And I don't know if I can move this without breaking it, so I'll try and get close to it. Mr. Mundy, could you give us a quick background of your experience as an appraiser?
As I mentioned, I've been appraising about 45 years, all, for the most part, all retail, commercial, industrial properties. Do not do very many homes at all. Every once in a while, a law firm will require me to do one, but barring that, 99% of the work is retail and industrial, vacant land, and so forth. A lot of retail, commercial, income-producing properties, special use properties over the years. Pretty much, can't think of very many things that I haven't at least looked at value-wise.
And you've looked at values in this particular area of Geneva, Kane County, et cetera, over the years?
Well, over the years I have, yes.
Okay. And we heard Mr. Argianis has been certified as an expert in court on appraised values. Have you also been certified as an expert or testified as an expert in court?
I have.
How many occasions? Do you have any idea?
Probably hundreds.
And what kind of companies do you do appraisal work for? Did you say FV? So I missed it. I apologize.
Law firms do not do a whole lot of bank work. The retail clients I deal with are people like Kohl's and the recently departed Bonton, which is Carson's, Nordstrom's, people like that.
Okay. In this case, what did you review?
In this case, I reviewed the information that you provided me. I looked at Mr. Argianis's report. I looked at various documents, letters from, I believe it was McDonald's attorney, some plans, inspected the property Sunday, and toured the area.
Okay. Do you happen to have the lease in front of you? You can work off mine.
If you go to page 3 of the lease. Okay. Could you point to the language in the lease that talks about, if at all, the 50% modification of the rent? Yes, under Article G, it says, if this covenant is broken, 1/2 of all payments required to be made by tenant under the lease shall be abated for as long as such breach continues. And you've also heard about the McDonald's letters, and you said you read those. How are values for retail commercial properties with ground leases usually determined? Based upon the net income. Okay. And when you say the net income, could you explain that for us? It's the contract rent. In most cases, it is net for ground leases, meaning the tenant pays for all expenses, taxes, so forth. Excuse me. And the net rent then, as Mr. Argianis pointed out, is capitalized into value using a capitalization rate. And is that how sophisticated developers that you've worked with decide the amount they're actually willing to pay for properties of this type? Yeah, they'll certainly do that. They might do a discounted cash flow analysis or something along those lines to show what they would anticipate the reversionary value to be, but pretty much that's what they're going to do, is capitalize the net income into value. And would they look at the term of the lease as well? Absolutely. And would a 50% reduction in rent affect the value a sophisticated developer is willing to pay for a property such as the one with McDonald's in it? Yes, it certainly would. Why? Because you're literally dropping, you're having a dramatic negative impact on the value of the property because of the rental income being reduced by that amount. And you heard Mr. Argianis talk about the difference between a $5,000 rental rate versus a $2,500 rental rate. Would you agree with with his calculation with that cap rate of 5%? Absolutely. Okay, could you go to section 14 of the lease? I think it's about page 11. Actually, it's tabs. Okay. It's page 11, the bottom of page 11, for those following along.
Another 20 years or 40 years. 2036.
At the in paragraph 14, it talks about, could you read the language that talks about the option, the purchase option? 14, the caption is options to purchase and right of first refusal to purchase. And then it goes on, I can read it if you'd like. The landlord grants the tenant the option to purchase the demised property, including all easements, covenants, benefits, and other rights granted under the leases, or under the lease, exercisable during the final year of the second option period. If tenant elects to exercise such option to purchase, tenant shall send landlord written notice of such election during such option period. Could you, I'm sorry, I probably should be more specific. Okay. Can you let us know where it talks about how you determine value under the option price? The very end of paragraph 14, it says the purchase price shall be the value of the demised premises as encumbered by the lease. So what is that? So can you explain that? It's very simple. What they're asking for is, and they're telling you that if you're going to exercise the option, the value of the option exercising has to be based upon the lease. The lease, therefore, is the lease terms, and therefore the rental income that's being derived. So in this case, possibly 50% less. Correct. And in fact, it talks, I think the next page goes on to talk about how each side would hire their own appraisal, et cetera, and that would be the basis of how you would be forced to appraise the property under this lease. Absolutely. So if the rental income stream was reduced 50%, that would affect the end purchase value significantly. Would that be fair to say? Very fair. If this was actually brought to fruition, the appraiser would have to go to the lease, value the lease based upon the terms. If the terms have called for now a 50% drop in value, he would have to consider that, and the value would have to be made on that consideration.
So it may not be exactly 50%, but it would be a significant reduction.
Well, it says 50%, and plus, I think it also alludes to real estate taxes and common area maintenance charges as well.
So the real estate taxes, well, they may go up as they happen to do out in the western suburbs where, unfortunately for all of us, if they went from 50,000 to 70,000 over a 5-year span, the tenant under this lease would only pay 50% of the real estate taxes as well as the 50% of the lease rate.
That's correct.
I don't want you to critique Mr. Argianis, but you heard his testimony, but I do have a couple questions. Do you ever provide an analysis, do you ever provide an analysis in your business relying primarily on assessed values to determine value?
No, never.
How about to determine a change in value before?
I've never done it, no.
Why not?
I don't look to the assessor as a reliable source in valuing properties. The assessors their primary function is they're trying to have uniformity. So given that caveat, it's hard for them to move away from one restaurant to another restaurant because they're trying to keep it all in line so that there's no problems within their township. So that sheer fact, I don't know actually of any of my peers that other than Mr. Argianis, that use or would use this as a basis for valuation.
Are there other types of analysis, if you had the time, that you could do to actually determine the effect of a use on an existing property?
Yeah, it could be very arduous to get the data, the proper data, but if you're able to find a similar circumstance, similar scenario where a property did sell based upon a reduced rental rate, I guess then it would be applicable.
Okay, so, but even if it wasn't a reduced rental rate, let's say that you have a use that is incompatible with the use next door.
Right.
Or
You
may
could-
or may not be incompatible from a value. You could then do a before and after sales analysis.
You could,
And that would be appropriate under use map, correct?
it would be.
Okay. And relying solely on assessed values, would that be appropriate under use map in your opinion?
Well, Mr. Argenis covered that, no, it's not something that I think that I've ever seen written that they talk about that, but as I said before, I've never done it. It's the first time I've ever heard of somebody doing it to reflect value.
I have nothing further, Mr. Mundy, or Commissioner obviously.
Any questions? Yes, ma'am.
I have a question. I might have missed it if you responded to this.
Okay.
But when you valued the property before the proposed project even was contemplated, how would the presence of that term in the lease that there might be a future 50% reduction in lease in the rent have impacted the value? Would you have considered that when you were looking at the value?
Yeah, it's actually a great question, and yes, you would. Generally, you're going to make sure and read the lease and read it well so that you would pick up stuff like that. And to be perfectly blunt, I don't know. I would have to sit back and think. I would certainly have disclosure on it, meaning within my report, make sure that it was recognized that this caveat is part of this lease, this stipulation, and it could very well. Then you'd have to make a decision, all right, how likely is it to happen and so forth. So again, I really haven't gone into that, I haven't thought about it, but you're absolutely right.
Thank you.
Any other questions?
Thank you very much.
Um,
Oh, sorry.
Would you come forward, please? If you have a question to this person?
Yeah, do I
Yes.
have now? Or?
Yes, go ahead and talk to him now.
Oh, okay, great. So one question, I actually want to follow up, so I just want to make sure I understand. Let's say you were tasked today, right now, August 29th or whatever it is, to do an appraisal on this exact property, knowing of the pending development, and being completely aware of the lease exactly as it is
I'm
today.
appraising the McDonald's store.
You're appraising the McDonald's store, knowing this development is where it is. without sidestepping and saying you do have a footnote, well, how would you apply that in the appraisal?
Again, I really hadn't gone to that
Just use
process.
your judgment. Tell us in your best judgment, knowing that.
No,
Sir,
Could Mr. Mundy still be allowed to finish his answer before he's cut off? That's all I'm asking.
yes, but please don't interrupt. Thank you. Yes, go
no, what
ahead.
I'm saying is that, I would have to, then, just like I answered the young lady, I have to contemplate that. So, don't know. I'd have to sit there. It's not something,
So is it
it's a
reasonable-
knee-jerk reaction.
Okay, but is it reasonable to assume that the value that you would put in today, knowing the value, let's take it one step further. Let's say this board says yes, and the village board says yes, prior to construction starting, which is what theoretically triggers this lease.
Okay.
So let's say 2 months from now, no construction, it's approved by the village. Would you say that the value between that point in time and the value 6 months later is any different? Your
For the
client,
McDonald's.
your client, let's say of the McDonald's property,
Okay.
your client asks you in your professional opinion, and for a bank, let's say you're appraising it for a bank, you have different standards, to give them an appraised value, knowing that this development is not yet happening, but is in the works and has been approved by the city, there's a building permit issue, but no construction has taken place. Therefore, the development could not have had any I can't say that.
Diminution, yeah.
Thank you.
Right.
In value, so what I'm asking for is, what is all other factors the same? From that moment to the moment that the construction starts or the new restaurant is open, what changes in the value? Does anything change in your professional judgment?
Well, I mean, the sheer fact, I think, once it's in stone that your restaurant is going to take place, right? Then that obviously has triggered, the article that's in the lease, in my opinion.
Well, but you're not really, I guess, so what you're telling me is that if you did an appraisal after the permit has been issued, that would not, I mean, how would you take that into account in your appraisal?
Well, I'd probably go and talk to the client and make sure that, and I assume
So it's a big deal.
McDonald's would be.
It would-
Exactly.
It would be a big deal.
Sir, please let him allow to speak.
Exactly, no, you're fine. And that's what I would make sure of that, number one. And then number two, realize, okay, if this really is going on, and it is, then, it sounds like you have to appraise it based upon, quote, the new terms.
Yeah, okay. So what do you think, in your judgment, do you think that the tax base and the assessed value and the tax rates for the McDonald's parcel are likely to change drastically over the coming 5 years if this property goes
I
forward?
can't tell you that.
But what does your judgment tell you? In your professional opinion, looking at all the different assessment, I mean, I'm sure you've been part of this. Do you think that the assessor is going to look at this and say, oh, well, now the value's high?
Well, I think the assessor could if he knew the circumstances, certainly.
Okay.
I mean, you would sort of assume that McDonald's would go in and go, hey, they just dropped or the owner, or the ground lease owner, would go in and say, hey, I just lost half my income.
All right, so here's another question. Let's say McDonald's somehow came to own title to the property today,
Okay?
all right? There's no Oberweis, there's nothing there. Would your appraisal from today to, in any way then, be affected by the development of the Oberweis property?
Probably not.
Okay, all right, thank you.
That's a good question.
Any other questions? All right, thank you.
Thank you.
Sir, I had a question on your Exhibit 7. For the assessed value history on the last page, when was the Oberweis built? I mean, was it built, I'm not sure what date they built there. So, I mean, I see a drop, but I don't know when Oberweis showed up.
I don't know either.
Maybe Mr. Oberweis could add to that. What?
2012.
2012 is when you arrived in Muskogee?
Way before 2015.
So it's pretty irrelevant.
Mr. Chairman, you want to ask the petitioner if they have any questions regarding the exhibits that were tendered for submission?
Yes, I will definitely do that. I just want to make sure that, are you going to present additional testimony?
Yes, sir. But if they wish to ask questions on,
Okay, that's fine. We will take the current exhibits in place and questions from the applicant.
Yeah, I mean, the only question I guess that I have is, do you have a copy of these, the two letters that are submitted? And, you know, again, I had the same amount of time that you all have had. They reference responses, and I'm wondering where the original emails were, or letters or whatever. So these are responses, but they're not providing their original notes to which these are responding? So I'm not
You
sure
can't
what-
direct that to me. I didn't submit the
Sorry.
exhibits.
Is there a question there, I guess, is my question.
What was the,
I'm here to answer
what was the contents of those? Where are they, and can we see them?
I don't have those with me.
Okay.
If you want to show me the letters, I will.
Well, it says, on behalf, I'm responding to your August 21st, 2019 letter.
Yes, okay.
So,
It's my letter.
so I'm just wondering what was in it, and
It's regarding our request
Yeah.
for McDonald's to intervene in the litigation between ourselves, you, and the city of Geneva.
Okay, and it says, we've reviewed the arguments raised by Geneva Center Council with respect to the enforceability of 4G, the ground lease. So presumably, you're making the argument that the rent abatement is not enforceable in some fashion?
I have not made that argument, no.
So then what do they mean by?
Geneva Center was your council and the people who own the center. It was not us. That was what was raised by Oberweis in the underlying litigation. We provided that information that your council
understand.
said, we provided that to McDonald's so they would be aware of the position
But
that
it's-
Oberweis was taking,
Yeah.
not the position we were taking.
Okay. Yeah, it's hard to know without all the, selected information available.
The only reason it's been submitted is for the issue of McDonald's has said very clearly on 2 occasions that they will be reducing the rent.
Yeah.
Okay, I guess we can move on to other topics.
Yes, at this time, as you may know, we had,
One
Can I
moment.
ask you a question?
Yes.
I'm sorry.
You said that the city is a party to this litigation, and can you explain how because I'm not sure how our role relates to this. How is the city part of this?
I don't think your role changes at all, and I shouldn't talk for Mr. Radovich, but I didn't bring that up, and I haven't talked about it other than an answer to a question, because I don't think it's relevant.
No,
to
the role of the Plan Commission here is to evaluate the petition that's before it and the documents that are presented on behalf of the petitioner and any objectors that provide testimony and so forth. This has been a resubmittal by this petitioner, and that should be the objective. There is pending litigation, that's public knowledge, that's a public record, but this is independent, this application is independent of that litigation.
All right, thank you. Mem, do you have anything else on that? All right, thank you.
We had 2 additional experts. One was a traffic engineer and another appraiser who could not testify on such short notice. We would ask that this be continued from here to the November 14th meeting so that we could have them attend.
I have a question before we make that motion. I feel like we've already approved this. This has already gone to city council and I think been approved, is that correct? From the prior meeting, the prior submission?
It was granted conditional approval, and since those conditions couldn't be satisfied, that's why we're here this evening.
And we're just here really reconsidering this because they want us to withdraw the easement,
To remove that condition.
to remove that easement condition, right?
It's the only change.
That's a sole change. That's a sole material change from what we saw on the first item.
So,
I have a question then. You haven't adopted the record from that hearing. So this is a new hearing with completely new evidence, and is that my understanding? Just so I'm understanding the process?
Talking about the applicant's submission in terms of what's changed from the original one.
No, but I'm trying to understand, and I apologize, I may not have been my time to do that, so if I
No, I'm-
stepped, I apologize. But I want to make sure I understand the process here. This is, my understanding that Mr. DeGroot said we had to have this is a completely new hearing.
This is a de novo process, sir. and that's what the commission has been advised. You're hearing this anew, again, because of what Mr. DeGroot said, that the petitioner has come back because it could not satisfy a condition on the previous application. So you're
So
considering
this
this
is
all.
all fair game?
Correct.
Okay,
Including any objections.
Yeah,
that's what my question was. Thank you.
yeah.
So if something were, if they were to withdraw this petition, the original one with the conditional approval would still be in effect?
That's correct, with the conditions.
Right, right. Okay.
The question, I think, is, as I understand from Mr. DeGroot, this hearing was announced and published in accordance with the city's code and operating procedure under the city code for planned unit developments. I think it's a discretion of this board whether or not the hearing can be continued. It's certainly your prerogative if you wish to continue the hearing. You're not obligated to, unless there were some other intervening circumstances that the Plan Commission thought deserved that continuance.
Is it possible to close the public hearing but not vote and allow staff to give us some guidance before the next meeting?
Correct. Under the procedures of the Plan Commission, you can bifurcate the process here. In other words, you can conduct the public hearing, close that public hearing, and not make a decision on that night. You have 45 days, correct, David? Yeah. 45 days, I believe, from the closure of the public hearing in which to render your recommendation. You are a recommending body to the City Council on this application. If you fail to make a recommendation after the close of the public hearing within that 45-day period, then it's considered a denial of the application.
A recommendation for denial.
A recommendation for denial, correct.
I have a
Yes.
question for Mr. Lutkinens, is that how you pronounce it?
With a name like that, you're close enough.
All right. You mentioned a wish to continue this because I think it was a traffic engineer and someone else were unable to make it on short notice.
Yes, sir.
I think there's ample notice given to which, like anyone else, they could have provided some testimony or questions or objections in writing, like others do from time to time and often. I don't know why that we would need to continue this because someone couldn't make it here this evening physically.
Let me tell you why I did not do that, and you can obviously, this is not my decision, it's
Right.
yours, obviously. The point is this, under Claren and under the case law that followed, if we were to submit written expert reports and them not be here, they would have the right to say that that report should not be considered because they did not have the opportunity to cross-examine. The law changed with Claren in the early 2000s that said, for any experts, you have to give the right to cross-examine. That's what I was doing with Mr. Argianis, and I understand the question. But if we came in with a traffic engineer and a report, I cannot authenticate that report, and they could say it doesn't count because we did not have the right to cross-examine. That's why we did not do it that way.
So the open point is traffic?
Traffic, and we have another appraiser, yes.
The probative value of even some of the exhibits that have been tendered to this commission tonight are questionable because of perhaps a foundation issue. But I think the commission can evaluate that themselves when at the close of the hearing.
Yeah, and I would just say those 6 exhibits we put into evidence, I personally have actual knowledge of and can authenticate. If anybody wants to question that, I'm here to be cross-examined on those if someone wishes to.
And we've got traffic studies and everything that your staff has been through, correct?
Correct.
And I don't know if these are the same as we'd seen before, but I read all of the exhibits and spent time with them, and they seem to make sense to me. So I don't know that I need personally any more laid out on the traffic studies in order to be able to vote on this evening myself.
I just wonder if we need some guidance from a legal point of view. This is obviously much more aggressive than it was the first time we heard it. And, you know, my personal, I don't know what you guys think of that or if you have any feedback, but my thought would be to close the public hearing. I'm also not really that much interested in hearing any more testimony, but I would be interested in hearing staff feedback on it and bifurcating the process and voting at a future date.
Well, I think I've advised the commission, it's your discretion as to whether or not you grant the continuance. I think that's like any, if you were a court of law, you'd have that discretion as well. The question of bifurcating, I've already indicated what your options are. You can close the public hearing and make a consideration on findings of fact and then make a recommendation to the city council. You can close the public hearing and delay that decision and the consideration of the findings of fact until another date. But as long as if you wait beyond the 45 days, then, and do not make a recommendation, then it's going to be considered a recommendation denying the application. Is everyone clear on that?
We have an
Just one
opportunity.
moment, sir. We want to make sure everybody in the commission understands what was just stated, so.
I guess my question is, will there be any future staff recommendations based on things that have been presented here tonight, or, you know, these 100 pages of exhibits that were just given to everybody here tonight?
I think, well, first of all, I think it's the practice of the development department to provide
Exactly.
a recommendation after the close of the public hearing.
Okay, so we maybe hear that tonight.
And as well as even suggestions or draft recommendations that you can adopt, modify, reject.
No, I understand all that. I'm just wondering if there's a reason to vote tonight or a reason to delay that vote till a future date to be determined.
I
Go-
have a
you could-
non-procedural question, so if you want to follow up on that, go ahead, and then I'll ask my question.
I was just going to say, typically we close the public hearing when we've heard all the testimony that's available to be heard. Then we'll enter into some discussion period, which is when David will share with us if he's got concrete or things to recommend to us, and we'll discuss other points resulting from the applicant and from the other testimony we've heard, and then we can decide, do we want to vote tonight or not? Because so I think there's some things that have to occur tonight before we actually make that decision.
Yeah, I mean, we had a lot of material presented to us today, so, I mean, it all has to get worked into the findings, so.
As I understand it, however, there's no other testimony by any objectors other than what you're requesting as far as the traffic engineer and
I would
for
ask for,
testimony, correct?
I would ask for a few minutes to do a closing state, to kind of summarize, but
And
as
I
far
assu-
as
I
live
assume that the-
testimony, no.
I assume the petitioner might want to do the same.
Yeah,
Some kind of
there's going to be.
summary or closing.
I think before we get there, I want to make sure there's no one else present that wants to talk about this issue before we get to summation. Anyone else here want to speak on this item? Okay. So given that, sir, do you want to give your closing remarks? And then we'll hear from the applicant.
Okay, I just want to make sure I completely understand where we're at. Is the motion to continue to the November 14th for further testimony
Received
denied?
no motion, no
Well,
motion has been made.
I'm
We're-
making it myself, and I'm asking for that continuance. And I guess I would just like to know if, you know, if you deny it, you deny it. I'm just trying to understand where we're at procedurally, and I think Mr. Radovich is kind of in the same place. We're just trying to understand it. If you say to me, Phil, you're done, and we're going to close at the end of this, then I know what I have to do. If you say the other way, I mean, I'm just looking for a decision from the board on that issue, or the commission on that issue.
We will give you one, but I want to hear from you again, and then I want to hear from the applicant, and then we will discuss whether
Okay.
we're going to continue or not. Oh,
Yeah, I don't know what I'm closing on. That's my problem, sir. I'm not trying to be, I'm not trying to be a pain. I just don't know what I mean, you don't want to hear from me twice, right? You don't, if I bring in new testimony and do it, you don't want to hear from me twice. That's all I'm trying to say here.
okay. Sorry.
Going to entertain a motion to continue it and take a vote, see if it passes?
Yeah.
Do we want to discuss it first, or is it appropriate?
No, I think you make the motion and see if
Yeah.
it flies.
Well,
This would be a motion to
The
continue.
motion has to be in a positive
yeah.
form, so.
So the motion needs to be whether to close the public hearing?
No,
Or to extend
no,
it,
the
actually,
motion needs to be,
extend it
make a
to
motion.
November 14th was the applicant.
I'd like to make a motion, Mr. Chairman, that we
person.
continue the public hearing until November 14th in order to allow additional testimony to be made.
Second. Moved and seconded, Celeste.
Second, I'm sorry, Slifka?
Yeah.
Evans,
Nay.
Passerag,
Nay.
Mead,
Nay.
Slifka,
Nay.
Stocking.
Nay.
Fails.
Well, normally, I think the process is to allow the petitioner to summarize first. So I would say that the applicant should be the first to make its summary, Mr. Chairman.
The procedure you said before was that the objectors would speak and then we would close.
Well, we'll let you speak
You'll have a rebuttal.
So I'm going to go then him, then me again.
Yeah, that's typical.
Yeah.
All right.
We've heard a lot.
So, for those of you that forgot to TiVo Law and Order, congratulations, we did that for you. Sorry, attempted humor. So I made a bunch of notes of things that I wanted to address. I'm going to try and do them as quickly as I can. But unfortunately, I feel like I have to say a variety of things. The first objector made a comment on, well, first off, high level. Everything, when you set everything aside, all of this is completely irrelevant to why we're here today. The staff report point blank states that. This is nothing to do with the entitlement process that we go through for the city. This is all about a private agreement that was made between, well, I guess originally it was Dial, because they used to own the McDonald's property and McDonald's, and then Bear Valley bought it. So, so I believe Dial, I don't, you have to dig, I don't understand where their financial interest is, but I suspect they feel a little bit exposed from their sale of the McDonald's to Bear Valley. Then she talked about the McDonald's value as well. And I think that what I've tried to drive home is there may be a changing of hands of value. It's possible that because of the lease provision, Bear Valley loses some money to McDonald's. I'm sorry, that's really unfortunate. But, I go back to the original analogy that I made on this whole thing, which it's like leasing a house to somebody and saying there's not going to, in the lease, your lease rate gets cut in half if there's a dog in the neighborhood, and then going and yelling at the neighbor for getting a dog. You don't have the right to do that. And the provision of how the original landlord intended on following through was to acquire another piece of the development so that they could block any amendments. They didn't do that. They never bought it. So in effect, what they did was they gave something up that they didn't have the right to give. That when you set everything aside, that's what happened. Now, that's irrelevant, frankly. It doesn't really matter for this purpose, and that's what the staff report acknowledges that. So that sort of is important. And I think it's when the argument's really weak, attorneys are really good at trying to confuse the issue and cause things like, oh gosh, what are we going to do? Our goal, we've been working on this for a long time, and it's been an exhausting process. Dave can attest to how complicated it's been, and their goal here is just a delay. I'm frankly don't believe that these two witnesses couldn't be here. I believe it was just one more way to kick it back a couple of weeks. Because that's what they've conveyed to our councils. We don't care. As long as we delay it, that's all we care about.
Objection.
You'll have time to speak next, sir.
So when we talk about and I'm not going to say the word diminution, is that the right word? Diminution of value. It's been a tongue twister for me. I think the heart of that is, are you putting up a strip club? It's not, is money changing hands between a landlord and a private agreement? We're an ice cream store, a hamburger restaurant, and a pizza joint. Somebody said it defies logic how it could not affect the value. It does probably transfer some value from the landlord to the tenant. But as their own appraiser acknowledged, the inherent value of the property doesn't change at all. I don't think that the assessed value is going to change. I don't think the tax base is going to change. All that really is happening is that the landlord is losing, and I'm sorry. And I suspect that ultimately they're probably doing this, right? Because they probably didn't read the lease carefully enough. They probably didn't do their due diligence when they bought the property. That's unfortunate. I would hate to be in that situation, but that doesn't affect us directly. He brought up the Skokie property. The Skokie property is actually in a TIF district, so I don't think it's comparable. The McDonald's he's talking about is across the street and down a little ways. And the three that Chuck talked about are the three most recent, as opposed to Skokie, which is older in terms of when we came in. And they're really pushing on how would you appraise a property. Chuck's job was not to appraise any property. His job was to assess his opinion around whether or not our building, our use is going to affect the inherent value, not the appraised value for a bank, but the way a strip, I hate to use that example, I'm sorry, but that's the most visible in my head. The way a strip club would affect the surrounding properties, because it's going to keep people away. It's going to drive, commercial traffic. Nobody wants to be right next to a strip club, so that's the kind of thing that plays in. That's not what's happening. It's an ice cream store. So there is a reallocation of equity. And on the issue of kicking it forward a couple of weeks or a month or whatever, we really have in good faith tried very hard to work through this and to address all the issues. And we really would hope that any advice or counsel that you need, that the folks are here and they can provide that. And you're talking about sort of the implications. The city's position, I believe, which is in the report, is this is a private agreement that doesn't have any bearing on the reasons we are here today. That this body and this discussion is around things that don't relate to that. So I would just humbly ask if it's possible to have a vote so we can move forward, because we'd like to get under construction and have it built through the winter. But you got to get some certain things done before it gets too cold for that to happen. So, and I'm happy to answer questions, and I'll let Phil do his talking. And thank you.
Thank you. Okay.
For the record, I am Bear Valley's counsel that supposedly said we were here for delay. I am the counsel for Bear Valley. Never been said. Not once. Not by me, not by anybody in my law firm. We are here to present you with the most evidence possible so you make the best decision possible. That's why we asked for the continuance. As you know, they have months, if not years, to prepare for these hearings. We have 15 days. And in this case, the original hearing that we were advised, and that wasn't set, was it was probably going to be November 14th. And I'm not trying to re-argue with this motion to continue, but I wanted you to understand why we're asking for it. It was only later that staff said, oh no, we're going to have a special hearing, a special night for this. And that we were given about 14 days notice. And it is what it is. But to say that we're here for delay purposes, we didn't bring in an expert to talk about value for delay purposes. We didn't want a traffic engineer to come in here so we could delay it. We'd much rather have him here. We've been working with another appraiser. He's been involved with this for a while. He's in Kansas today. He had to fly to Kansas. When we knew the 14 days in advance, there was nothing we could do about it. One thing we haven't heard from anybody of any ability for the petitioner, and let's be honest, it's the petitioner's burden of proof. It's not my burden of proof to do anything. The Living Word case, which handles special uses, shows everybody that it's clear the burden of proof is on the applicant, not on me. So the question you have to ask yourself is, have they met those 9 factors? And have they met them with people who can actually testify to them? Mr. Argianis, as we heard, is not a land planner. All he is an appraiser, and that's great. His opinion on diminution of value is something you should listen to. We'll talk about it in a minute, whether it's worthwhile. But his opinion on these other 8 factors is absolutely useless. If he brought in a land planner and testified to some of them, and they do have someone to testify to parking, they do have someone to testify about traffic, but they don't have anybody to testify about any other issue. That's their burden. As I said, it's not mine. And they haven't testified that in this hearing. Mr. Argianis doesn't have that background. We went through it. He's an appraiser. That's what he is. More power to him. He's been doing it for 40 years or whatever it is. But let's talk about Mr. Argianis. First of all, I testified under oath that the McDonald's is right across the street, and it is. We heard Mr. Oberweis say we picked the last 3 because, and we heard earlier, the Skokie Oberweis store was built in 2012. I ask you to look at page 3 of Mr. Argianis' report. The Bolingbrook store was also built in 2012. Mr. Argianis, besides the fact that assessed values have no position, no worth whatsoever in matters like this, he cherry-picked it. He picked 3, 2 of which could not be further, could not even be, are not close in concept to Geneva. No one has ever said that Bloomington Normal, Champaign, and Geneva in the same sentence until today. 2 are college towns. They're in rural areas. The days of Geneva being a rural area are long gone. And to my knowledge, we've never had a college here. They're not comparable. But we picked them anyway. Why? Because they fit their theory. And they didn't give you what they really should be giving you, which is comparable sales. Did we have time to do that? No, we didn't. We had 14 days' notice. We just heard it would take at least 18 days to do that from Mr. Argianis. So he relies on assessed values. Fine. But it's useless. It's absolutely useless, just for the reasons he told you. There's so many factors depending on it, and to do it right, what does he do usually? He calls, he checks green sheets, he interviews people who are involved, none of which were done here. I know staff has made this statement, and they made it the last time I understand as well, that this contract is irrelevant. The problem is, I have looked, Oberweis' counsel has looked. There's nothing in the law that says that. Mr. DeGroot cannot cite a case to that because it doesn't exist. So you go, what's the language of your ordinance? One is they have to prove each factor. I heard at the last hearing Mr. DeGroot said it's a totality, and that may be true under LaSalle factors, but it's not true under your ordinance. Your ordinance says they have to prove each factor. So the question on standard 2 is, the proposed building or use will not diminish the value of adjacent and nearby properties. We just heard there's no doubt it's going to diminish the value of adjacent and nearby properties. There's no exclusion for it being in a contract. The question is, does it diminish the value? Answer, yes. I don't think anybody in this room believes it doesn't diminish the value of the property. Oberweis is relying on, and I know the Plan Commission in the past relied upon Mr. DeGroot's statement of, I guess, law, But there's no basis for it. There's no support for it anywhere in the law of the state of Illinois. Trust me, we've looked. Oberweis has looked. There is none. So you go back to what does the language in the ordinance say? And that is, the proposed building or use will not diminish the value. In this case, it does. In and of itself, you have to deny it just for that. And I know we go, well, this was a hearing we already had, we already voted, but as Mr. Radovich properly said, this is a new hearing. Everything you heard at that last hearing is absolutely irrelevant to today. I know that stinks, it's really hard to do in our head, at least it is in mine, but it's what is in the evidence today, what is in that record that you have today. And today, they haven't met factor number one. They haven't showed us what the comprehensive plan is. They haven't shown us it's consistent. No one's testified to that has any land planning, any ability. We've shown that Mr. Argianis cannot prove number two. We have heard from the traffic engineer, and I have not had the opportunity I don't have any evidence today to deny that because of the fact that I couldn't get my traffic engineer here today. Ingress and egress number 4, same issue. Character of the area will not adversely affect the character. We haven't heard one word about that. One word. The only thing I think this Mr. Argianis relies upon is, well, it's not going to diminish the value. We've already talked about that. I'm not going to bother you with it again. 6, the proposed use at the specified location will not adversely affect the use and development of adjacent and nearby properties. We don't know that. No one with the ability to competently testify has been brought here to testify about that. Again, not my burden of proof, theirs. Number 7, adequate drainage, parking, other necessary. I don't have anybody to deny that. They do have evidence to that effect. The proposed building, other structures and use shall comply with all regulations, conditions, or requirements of the city applicable to such building, structure, or use. Again, we don't really know. No one's testified to it. The exterior architectural appeal, I can't read today, and function of any proposed structure will not be at variance with the exterior architectural appeal and functional plan. Again, no one sat here and testified. As your ordinance says, they have to meet each of those elements. They haven't even met the totality argument. They sure as heck haven't met each. So I'd ask that you deny the petition for special use, or not deny, recommend denial. That's not, I understand that's your role, is to recommend. And we would ask that you recommend recommend denial to the city council. And I really want to thank you for your time. I know this is probably a little more invasive than what most of you expect at these hearings, but it's obviously an important issue to our clients. And thank you for your time.
Okay, thank you. Yes.
Mr. Chairman, I think I did indicate that the applicant should get some rebuttal, I guess if it's a rebuttal to what the objector said. And Ms. Ward did you want to say anything, Ms. Ward?
I did not. I just want to clarify. I know you said you weren't sure what Dial's role was. Dial is the current lot owner, so that's primarily.
No,
Thank you for that.
No, so my comment was, I'm not sure Dial's financial interest. I know Dial is a current lot owner, but Dial used to own the McDonald's. So, as I was saying, my best guess is that they have some sort of financial risk that if half of the rent gets cut in half, that they get sued. So I think that's my assumption. I don't know. So, number one, this has been aside of this issue, this has been a very standard process. He said we didn't say anything about the character of the area. Actually, I did. I mean, one of the comments I made is this is a pretty standard use when you just drive up and down Randall Road from Main Street in Batavia to, oh gosh, like all the way up to 38. That whole area, obviously, I think we probably all live, eat, and shop right there regularly. I live in Batavia, so I guess I didn't even say that. I live in Batavia, so this is my stomping grounds constantly. He also referenced that, gosh, we only had 14 days. Well, that's not accurate because this was originally on the agenda for October 10th, and they were aware of that. It got continued because we wanted to or rescheduled because we wanted to make sure that the correct notice was given. But so they've at least known about it for a month or something like that, so didn't bother to mention that, which, you know. Bolingbrook East, I don't know what he was referring to. Maybe it was in there. And if it was wrong in Chuck's report, then it was wrong. It opened in 2014. The Skokie property opened in 2012. Skokie was the first multi-brand location that we've had in the company. I remember it well. Bolingbrook East opened in 2014. Champaign and Bloomington were after that. I don't remember exactly when. You know, he talks about that there's no case that talks to this issue. There's also no case that says the sun's going to come out tomorrow. I mean, it just defies logic to me. In order for the arguments that he's making to hold water, what would have to be true is that we could enter into an agreement with a landlord that says if another ice cream store opens up in a 100-mile radius, our rent gets cut in half. And then when somebody tries to do that, we go and kick and scream and say, our rent's going to get cut in half because there's an ice cream store. It's silliness. I mean, and I apologize for my frustration. I'm so sick of dealing with this. And it's such puffery and, you know, smoke and mirrors left and right trying to confuse the situation. The reality is it's not why we're here. It has nothing to do with why we're here. If I own the building, I might do the same thing, right? I mean, if you're looking at a reduction in your rent, you're going to kick and fight and scream and do everything you can everywhere along the way. And I'm sorry, but that doesn't mean that valuable real estate shouldn't be utilized by everybody that lives in the area. And that's a equally silly argument. So we really appreciate you coming in and being here. I know this is probably a lot longer than you thought you bargained for. I definitely appreciate it, and we hope to be part of the city of Geneva in the near future. Thanks.
Thank you.
And I know I'm not allowed, but I do have to say one thing. We were not provided the notice of October 10th. I heard that's one of the reasons. The first time I heard, the first time I was advised about the October 29th hearing was actually on October 28th by Mr. Kirk, who was Geneva. The first time we were made aware. So I just want to say that for the record, we did not have 1 month.
You didn't get your client didn't get the notice for the October 29th meeting prior?
I just said that.
And you didn't know that it was on the agenda for October 10th?
Correct. We got I'm sorry, we did not have any notice of the October 10th. One of the reasons is.
Were you aware of it?
No.
Or was anybody in your client aware of it?
Okay.
They were talking about it
We
with.
don't want to debate this. I mean, again, it's.
I think-
it's
Not
a-
aware of it. The first time I became aware of this hearing was the date of, was,
This has been properly
Yeah.
noticed.
so I just wanted
that's
to,
fine.
I'm just trying to correct the record, and I'm done. That's all I wanted to say.
All right, thank you.
Mr. Chairman, I'd like to make a motion, we close the public hearing.
Second.
Moved and seconded. Celeste.
Okay, Evans,
Aye.
Messerag,
Aye.
Mead,
Aye.
Slivka,
Aye.
Stocking.
Aye.
That's it for you.
Mr. Chairman, I think the development director and myself recommend that the Plan Commission adjourn this meeting to a date certain for considerations of proposed findings and a staff report instead of considering it at tonight's meeting.
So then,
Should we hold our discussion of any points tonight until that meeting?
I think that's appropriate.
Okay.
That's a discretion of the commission, but I think until the staff has issued its report, it might be more germane to have that discussion at that time.
That's fine. I'll just,
Mr. DeGroot, you agree?
I agree.
just have to jot a few things down.
Yeah, there's a little bit presented today, so,
But you need to make it a date certain,
yeah, we
Mr.
need to
Chairman.
make when we're going to
David, are we able to,
consider.
the next scheduled meeting would be November 14th, right?
We could do the second Thursday in November if we want.
Isn't that,
That's
There's
Thanksgiving.
something else on the agenda?
But November 14th would be the only date I think we can make within 45 days. And I'm not sure if the December one is within 45 days.
first, second, third? It says 14th, right? It's 14 days from now. Or
But the-
16
For
days.
November, but if we wanted to move it back to December,
Should still be within 45
Right.
days.
so we could continue it to November 14th. December 12th would be the next available meeting after that.
Why wouldn't we want it to be?
That would still be
I think
within 45
you're more
days.
concerned with the work you have to do. I mean, we can obviously be ready.
We already have other items published for the November 14th meeting.
Right.
So we will have other business that evening.
Is that our cannabis
That
discussion?
is the cannabis discussion.
Oh, yeah.
So
So that's
is it
gonna be a big
possible
one.
to do a date that's not a second, or as we did with this meeting, to do an intermediate date that would
I'd be okay with that.
give you more
I
time?
would too.
Yeah, I don't wanna
I would-
double
I don't
it up
want,
with the
I don't want to make
cannabis
them wait
discussion.
longer than they have.
That one's gonna go.
I don't want to go all the way to December for,
Sorry?
I would prefer not to make the applicant wait all the way to December for
Right.
another meeting.
Chuck's giving me scores of the votes.
I mean, the public hearing's been closed, so it'll be just the staff report deliberation.
Yeah, the 14th meeting's gonna be long, though.
What's
I
that?
would
So
anticipate.
will the December meeting, though. That's the affordable housing discussion.
Oh, my
So, yeah.
Yeah, we've got a heck of
Gotta
a
pick
schedule
one.
coming up.
Pick your poison on that one.
Really.
Right, so the next meeting should go quick. The next meeting on this issue should go quicker, is what you're saying, right?
Well, the public hearing's over, so it'll be our discussion
over.
on a
Just
motion.
that,
Discussing the
our
the
discussion.
staff report and the findings and giving our input. But still, it's just the longest, the meetings are gonna go along. I mean, we're gonna be pooped.
Well, I'm okay with the special meeting like tonight
Well,
was.
I'm okay with that, or I'm okay going long on the 14th.
Well, it depends, when would the special what are the
How much time do you need?
choices for a special meeting date?
With the holiday week in November,
Yeah, because
and Mondays are pretty much out with council meetings. And
About the-
Tuesday's out.
About the 7th, next week.
I couldn't make it on the 7th. Well,
The
I
12th?
could, but it wouldn't be
12th?
easy. I'm okay.
How about the 12th?
Before the meeting.
It's 2 weeks from tonight.
That works for me.
Is that enough notice?
Do you have enough time?
I'm not sure that, I'd have to make sure this room's available, because sometimes there's other committees that meet here.
Can we meet at Public Works? Somewhere else?
And so it has to be to a date certain tonight?
Yeah,
if we
we have to
continue
put
it?
it to a date.
Is it possible to pick a date and change it in the future between now and then, since it's not a public hearing?
It has-
Well, it makes it more, you want to notify everybody that's here, that ability, plus, I think you'd probably have to publish it.
Could we select 2 weeks from tonight, and if the room is not available, then we can provide something further out?
Do you have that schedule?
I can't pull up the room.
Can you pull it up on one of these?
If the commission would like, I could go to my office and pull it up there.
I would,
Take your
that'd be
time.
great.
fine.
And then we have
Yeah.
date certain.
Yeah.
Because I think we've got 1, 2, 3.
I'm good with the 12th. I can do it.
I can do the 12th.
What?
Yeah,
November?
yeah.
Better be able to do the 12th now that I open my mouth.
So
I can do the 12th.
if right here, we got a quorum, so
Yeah,
we
what
know we
time
can
is-
go, at least
It's a
go.
Tuesday.
Yeah, I know. I need to look at my other calendar, just so there's something else. The 12th. Just wanna check. Do you want to keep?
Which ones would you like? I read most of the exhibits while we were
Yeah,
being handed them.
I'll just ask him to send me a copy.
Do we have an extra copy for the?
I don't have an extra one. I gave mine to David, so he's got it in the record.
The 12th is okay.
I could give mine.
What do you need?
I just
You know,
would like a copy
you want a
of the
copy of what that
exhibits.
gentleman?
Here are the exhibits.
I'll give you,
I think we can cobble something, because I reviewed them while you were talking.
give her mine and I can get another one.
Same here.
Okay.
Here,
There you go.
those.
Thank
Complete
you,
set.
I
Sure.
appreciate it.
And you took a picture of that, right?
Yes, thank you.
All right. Ignore my work number.
Oh, yeah, there's a correction on, I'll tell David,
Yeah.
on the phone number.
Chairman, one thing that we're checking with David, the city council meets just twice a month now. They have their committee of the whole meetings coincidentally or coterminously with their city council meetings. So the the second and fourth Mondays, this chamber would be available.
Ah,
Okay.
so that's the 11th.
First and third Mondays are the city council
Second,
meetings.
fourth. Second would be no
Second and fourth.
Veterans Day, which is the city closed.
I don't know, probably, but
I would think.
That's the 11th, so
Yeah, so the
11th and 23rd.
14th and 28th would,
28th is Thanksgiving, unfortunately.
well, I'm talking about,
Oh.
October.
Oh.
Oh, I'm sorry, I'm looking at the wrong date. Yeah, I'm sorry. It would be the 11th and 25th,
The 12th should be open.
12th.
Okay.
Okay.
Go with that?
Do we need a motion for that, or do we just need, we
You
just,
should have a motion and a second and a,
all right.
well, when you're ready to adjourn the meeting to a date and time certain and location.
Mr. Chairman, I'd like to make a motion to adjourn and reschedule or continue the meeting on a date certain, Tuesday, November 12th, 2019,
At 7 PM.
at 7 PM
In this chamber.
in this room.
Second.
moved and seconded, Celeste.
Okay, Evans,
Aye.
Esserag,
Aye.
Mead,
Aye.
Slivka,
Aye.
and Stuckey.
Aye.
That passes.
Okay, very good. So, see you then. Thank you.
How do you sign out?
Oh, I didn't even think about that. Just,
Does this,
close it. Just close it.
okay. It says don't shut down, but,
No. Shut down or sign out, and then you can click that, and you can click sign out, John. You right-click down in the lower right corner on your little Windows symbol.
okay.
I think that's
Right, click on that, and then go shut down or sign out, second option, and then just sign out.
Oh, there we go, okay. Okay,
Where are your
yeah. go ahead.
Appreciate your time, thank you. Thanks. Holman's got a-
Tuesday,
Anything else,
11,
David?
12.
The only other business I had was to update you on the upcoming meetings, which I think I've already done. We have now recreational cannabis on November 14th, and then in December, we'll have the discussion on affordable housing incentives. Other than that, there's nothing definitely scheduled at this point.
Are those just the only items on those agendas, or are there other things we're dealing with?
Right,
other
yeah,
than-
for the 14th, that's the only item on the agenda,
Okay,
and we don't have anything else pending for the 12th. in
okay, so
December
we're just meeting to talk
on
about,
those issues.
okay.
Any activity on Shodine? Millrace?
We're still waiting for formal response from IDOT
On the turning lane?
on whether or not they'll allow the on-street parking and then the points of
Okay.
ingress and egress from the site. So once we have that formal response, we can continue to massage the site plan and lock down the access points and parking.
Okay.
we thinking the cannabis is gonna be a one-night deal, or, I mean, obviously, we don't know for sure, but
That's a good
That's-
point.
We'll have to see how the discussion goes. We're working on the amendments for your consideration. We're also working on kind of mapping out where they might be, where the various uses might be appropriate and buffer distances from other incompatible uses. So just kind of walking through those one by one.
So,
I assume, sorry.
go ahead, Brad.
I was just thinking, I assume a lot of it is just gonna be people wanting to vent one way or another on the whole issue in general, right?
Is that a public hearing then?
It is a public hearing.
I mean, yeah, like, do we even want
They're
to
not.
talk about this?
Well,
Yeah.
You know?
As a
I
city,
know
we have
that
an option to
everybody's
say
gonna be
no,
too
too, right?
interested in
Yes.
the,
Correct.
I think it's just.
We know
it's
that
not
St. Charles
appropriate.
is going ahead with it.
Why are we even thinking about
North
that?
Aurora is.
Yeah,
Right.
I would expect we get some of that, so.
And the city council meeting on it, I mean, there were people that attended to speak on the issue, but it wasn't overwhelming. I mean, there was maybe a
Right.
dozen people,
Hope for the same.
Okay.
and kind of 50-50 on their views.
Okay.
All right, see you, Chuck.
Thank you.
see ya, thank you for your help.
Sure.
Yeah,
Okay.
go Nance.
Nothing else?
Okay.